Thank you all very much for coming. My name is Chad Simmons. I'm with the Safe and Green campaign. We're a grassroots organization that have been actively working to close and replace Vermont Yankee. It's a really exciting evening, and I'm very glad to see so many people here. I know it's a beautiful night, and I think we're going to have a great discussion. So the words that have been going through my mind over the last 26 hours, and it's a happy thought. These are happy words. I'm not usually a fan of all caps when I read emails or something, but in the verdict that was the verdict, the decision. Thank you. That came down. Thank you, Randy. That came down yesterday. These words stuck in my mind. Conclusion. Therefore, plaintiff's motion for preliminary injunction, docket 4, is denied. So ordered. Dated at Brattleboro in the District of Vermont this 18th of day, July 2011. Honorary Garvin Murtha, United States District Judge. Thank you. Exactly. We have so much to be proud of. There is definitely a lot to do in the next few months, and there's definitely a lot of decisions that will come down. But this decision happened because, and we're here tonight having this discussion, because people power worked and democracy worked. We expected this to happen. We expected it to go through the court system, and Entergy did not expect the people power to overcome. So congratulations to everyone's efforts and success. Like I said, we have a lot to do ahead of time, but I think we really should be happy about the decision that was given yesterday. So today we have a really exciting event, and I think we have two panelists that I believe are going to have some really great things to say about what we've seen over the last 26 hours, and then kind of looking out a little bit about where we're going to go. I'll take questions. We'll take questions later and everything.
The full 18 pages is available.
Okay. Yeah, Peter. I'll make some announcements in a little bit. So basically, this event is being sponsored by the Safe and Green campaign, co-sponsored by the Citizens Awareness Network and Nuclear Free Vermont. What we're going to do tonight, it is here on in the New England Coalition. BCTV, the Brattleboro Community Television, is filming this, and they'll have this up on their channels very soon. We are also streaming this, so people at home can watch this, and we'll be taping this as well. It'll actually be recorded so people can look back on it. You can find all of this on our Facebook page at facebook.com/shutdownvermontyankee, and you can get all the information there. So the agenda tonight, what we're going to do is have a presentation by our two guest panelists on the preemption in the Entergy versus Vermont lawsuit. We'll go right into a moderated discussion, so we'll take questions and asking people to keep it to a question, a short question if that, and then we'll have a discussion for about a half hour, 45 minutes, depending on how long we have the presenters talk. And then we'll have Clay Turnbull from the New England Coalition. He'll talk a little bit about what the New England Coalition is up to. And then we'll wrap up with the Safe and Green campaign, and we'll give a brief statement about what we're thinking of and our reaction towards the ruling. And then we'll wrap up with we've got some events coming up in the next couple of months as well, actually over the next week, so we'll do that. So without further ado, tonight's two presenters we're really excited to have down here. Patrick Parento is a senior counsel for the Environmental and Natural Resources Law Clinic and professor of law at Vermont Law School. He is former counsel to the National Wildlife Federal EPA Region 1, that's in Boston, U.S. Fish and Wildlife, and is a former commissioner of the Vermont Department of Environmental Conservation. Donald Kreis, am I pronouncing that right? Kreis, Donald Kreis, thank you, is the assistant professor of law and associate director, the Institute for Energy and the Environment, and he joined the Vermont Law School after a 15-year career in the government, most recently as a general counsel of the New Hampshire Public Utilities Commission. Both have been following this case extensively especially obviously over the last couple of weeks. And you can actually find their blog. They've been writing extensively about it over the last couple of weeks at the Vermont Law School's faculty blog. So without further ado, I will turn it over to the two of them to talk a little bit more in detail about this case.
So, in the spirit of fairness, Don and I have agreed to flip a coin to see who goes first. Call it, my friend.
Heads.
Heads it is.
All right. Gosh. Let me just say, I feel really bad. And so I just want to tell you that I love Brattleboro. I love the Brattleboro Food Co-op. I love what you folks are doing. And so I would love it if Vermont Yankee were to be banished from the face of the earth, just like Maine Yankee was. I used to live in Maine. And so having said all of those things and having now thanked you for welcoming me to your town, I must now tell you, please do not shoot the messenger, because the optimistic and bright and democracy-affirming introduction that I just heard is totally at variance with my view of what Judge Murtha did yesterday, having read his 18-page opinion. And I guess I really owe you an explanation of why. I really think that there is no comfort in Judge Murtha's decision denying Vermont Yankee and its owners a temporary injunction. Why is that? Well, for one thing, it was, I think, clear to any thinking person beforehand that Entergy's case for a temporary injunction was very, very thin. And you see that Judge Murtha took a very no-nonsense, no BS approach to the arguments that Entergy made. If you remember, particularly if you were at the hearing, I guess some of you were, the witness for Entergy, John Herron, made a big show of sort of, but not really threatening to shut the plant down permanently if Judge Murtha didn't grant an injunction. And of course, he flat out looked Mr. Herron in the eye and said, "Are you telling me you will shut the plant down if I don't give you the injunction?" And of course, they stopped short of saying that. And Judge Murtha, if you've read his opinion, you know that he took note of that and basically said, look, you are not going to roll me, and this relief that you're asking for is really just relief from plain old business risk that should have, and I think was, pretty obvious to Entergy from the moment they took over the keys to the plant in 2002, and certainly by 2006, by the time, do I need to speak louder? Is that? Okay, great, I'm sorry. It's an illusion because I'm standing in front of this microphone, okay. So anyway, I think it was pretty clear to Judge Murtha, as it was clear to everybody else, that this request for a temporary injunction was really a request for relief from the effects of plain old garden variety business risk, because when Entergy bought the plant, they knew for certain that their operating license that they were taking over expired on March 21st of this coming year, and that certainty is something that they have been able to deal with and have had to deal with since they bought the plant. And a big company like Entergy is doing all kinds of scenario planning and business planning and financial planning, so they're not in any peril. And I flat out predict that notwithstanding their threat to shut the plant down if they didn't get the injunction, I predict that they will in fact order their fuel rods, and they will in fact move forward with their refueling and everything else they need to do in order to keep the plant running past March 21st. Why do I think that they're going to do that? Well, maybe some of you have read Judge Murtha's order. I have read it, and I will tell you that even though Judge Murtha made very explicit his refusal to issue a ruling on the merits of the case, something he could have done, because the request for a temporary injunction would have, had he granted it, required him to find a likelihood of success on the merits. He refused to do that, but then I think he telegraphed to Entergy, and perhaps to the rest of us, the message that he is taking their claims very, very seriously and thinks that they might just win the case. Where do I get that idea from? Well, I'll tell you. I'm reading from page 3 of the decision. The motion is denied because Entergy has failed to show that any irreparable harm it may incur between now and a decision on the merits would be, or is likely to be, ameliorated by a preliminary injunction in the short time before this court decides Entergy's claims. dot, dot, dot. The court notes, however, that Entergy has raised serious questions regarding its Atomic Energy Act preemption claim. Entergy has raised serious questions regarding its Atomic Energy Act preemption claim, warranting further briefing and a prompt, full-dress trial on the merits. Now, you can read this however you want, and it's capable of several different readings. My reading of it is that Judge Murtha is telling Entergy, you know, I will get you an answer in time for you to make the business judgments that you need to make, and the answer you may get will be a favorable one. I think he is encouraging Entergy more than he is discouraging them. I noticed that my colleague Cheryl Hanna and I, last night when we got a hold of this decision, were both, we live about 90 miles from each other, and so we were sitting in our respective living rooms, tapping on our computers, and we both put up a blog post this morning, and we both said things that were remarkably similar to each other without consulting with each other, and we were both quite taken with footnotes 2 and 3 of Judge Murtha's opinion. Why were we taken with it? Well, if you look at footnotes 2 and 3, you see that Judge Murtha is he's impressed by the prolixity and complexity and impenetrability, possibly, of the statutory scheme that the Vermont legislature has adopted and that he is charged with reviewing. For one thing, he has a problem of figuring out, since he has to deal with this question of legislative intent, at what point in time does the intent of the legislature become relevant? Where is the moment at which the legislature's intent is the relevant moment? Was it when the legislature acted in 2006? Or was it when the legislature acted in 2010 when the Senate declined to vote, I guess you would say, not to relicense Vermont Yankee under state law? I think the answer is 2006. Because I think what the legislature did in 2006 when it adopted Act 160 was it essentially passed a statute saying this plant is no longer authorized to operate under Vermont law after March 21st, period. And even though there's a mechanism in the statute that says, well, the legislature can take more votes as that date approaches, it's true that the legislature is always free to change the law. So even without a provision like that, the legislature would have been free to come back in 2010 and repeal the 2006 statute. So I think what the legislature did or actually didn't do in 2010 is kind of irrelevant, and I'm pretty sure that's what Judge Murtha will ultimately come down and say himself. And then there is footnote 3, in which Judge Murtha says, the court is aware the challenged statutes contain words that may or may not permit consideration of preempted grounds for granting or denying certificates of public good, and that the legislative history of the challenged enactments contain numerous references to safety, some of which may be problematic, some of which may merely reflect legislators' responsible recognition that Vermont cannot regulate radiological health and safety. Act 189 commissioned a study of reliability, which initiated ongoing oversight at Vermont Yankee that appears to examine numerous aspects of radiological safety affecting reliability. It is not clear if reliability oversight pursuant to that enactment is still ongoing. I read that as an expression of real concern on the part of Judge Murtha that Vermont's legislature, when it acted in 2006, and 2010 possibly, really was regulating radiological safety. And as we all know, the central issue in this case was whether Vermont has intruded into grounds that are no longer within the state's authority because of the Supremacy Clause of the U.S. Constitution and the Atomic Energy Act, which reserves to the federal government and the Nuclear Regulatory Commission the right to regulate radiological safety. Okay. Did you notice that in this 18-page order, there is absolutely no reference anywhere to, I already heard it from somebody, this infamous document, the infamous Memorandum of Understanding between the state of Vermont and Entergy that was signed at the time the plant's transfer to Entergy was approved. Now, it's hard to draw conclusions from the absence of something. I read that as a sign that whatever is in the MOU, memorandum of understanding, is not ultimately going to be relevant to how this case is decided. This case is about preemption. It's not about what Entergy, I don't think, either did or did not agree to in the MOU. And if you remember, there's language in the MOU in which Entergy agreed not to sue the state of Vermont over the Public Service Board's assertion of jurisdiction to relicense the plant. Okay. I continue to have the following opinion that I would like to share with you, and that is, I still don't get what evidence the court needs to produce in order to decide this case. Questions of preemption are what we lawyers would call pure questions of law, which means people coming into the courtroom and testifying about who said what to whom or who meant what when they voted for a bill, or who said what to whom when the MOU was negotiated. I really think that's all irrelevant, that is. And so I think that Judge Murtha's decision to accelerate the trial date so that this case will be heard by him on its merits in mid-September is a sign that really this case can be decided rather quickly. And I fear that Vermont is in a more tenuous place than the state's victory in this injunction decision would lead some of you to believe. So with that, I think I'll let my colleague, Professor Parento, tell you why I'm wrong.
Which I'm only too happy to do. Actually, Don and I agree on more than we disagree on, but you know, the ancient Druids used to slaughter animals and study the entrails to predict the future and sort out the problems of their society. That's kind of what we're doing here tonight. And frankly, you're all as capable as we are of speculating as to what's on Judge Murtha's mind. We don't claim any particular wisdom, to be honest with you, about that. We have no idea, frankly, how he's going to rule. He may not have any idea how he's going to rule at this point. So let me just go ahead and speculate anyway. Don reads the decision yesterday as a wink and a nod to Entergy. I can't give you the injunction. Go ahead and buy the fuel rods. You'll be happy in the end. Maybe. I read it as saying to the state, you haven't done all you need to do to build me a record to rule in your favor. Okay? And if you're at the hearing, you probably remember that the state, when it came time to put on evidence of, well, if it wasn't radiation safety, what was it that motivated the legislature? And if you were like me, you sat there underwhelmed with the state's presentation on those points. I think it's fair to say that there was quite a bit of confusion in the legislative history surrounding these critical statutes, Act 74, Act 160, Act 189. I think we can all be honest and say that safety was a concern of people. Why wouldn't it be a concern of people in the state of Vermont with a nuclear power plant operated by a corporation who had misstated repeatedly under oath the way that the plant was operating? Why wouldn't people be concerned about safety and reliability? There's nothing in federal law that says you can't be concerned about safety and reliability. There's nothing in the First Amendment to the United States Constitution that prohibits Vermont's legislature from talking about, being concerned about, raising issues about radiation safety connected with Vermont Yankee. What federal law clearly does forbid is for the state to attempt to regulate health and safety related to radiation risks of nuclear power. Nobody disagrees with that, neither the state nor Entergy nor anybody else, Don or I. Nobody disagrees that when it comes to that narrow question, who has control over the radiation risks of Vermont Yankee, it's the Nuclear Regulatory Commission, period. Now, that may not be good public policy, folks, but that is the law right now. And until it's changed, that is the law. NRC will decide whether that plant is safe, whether we like it or not. That's the end of the debate, the end of the discussion on that point. What is also clear, to me anyway, in reading the only precedent we have on this question from the United States Supreme Court, the case you've all heard about if you've been following this matter, PGE, the Pacific Gas and Electric case out of California from the mid-'80s, the only time the Supreme Court has ever had occasion to address the extent to which the Atomic Energy Act preempts state power to decide whether nuclear power plants will be built and operated within their states. My reading of the Supreme Court precedent on this question is the court was crystal clear. If a state does not want a nuclear power plant operating within its borders, it is not forced to do so by the Atomic Energy Act. It cannot ban a nuclear power plant, and it probably cannot shut down a nuclear power plant based on safety considerations. But it certainly can shut down an operating nuclear power plant for other reasons. The question is, what are those other reasons? And my view of Judge Murtha is he's not satisfied yet that the state has put forward a case that convinces not only him. Keep in mind, this is the record that's going all the way up the food chain to the Second Circuit, possibly to the United States Supreme Court. What is done up the street here in Brattleboro will determine the fate of this decision when it finally reaches the United States Supreme Court. There's no do-over. There's no making up for missed opportunities. There's no building, padding, beefing up the record later. It either happens here, now, on September 12th, or it's not in the record. Judge Murtha could very well side with the state and be overturned by the Second Circuit or by a very conservative U.S. Supreme Court. So he's very mindful of this. He's a very, very seasoned judge. He is our senior retired status judge on the U.S. District Bench here in Vermont. He's not a flashy guy. Nobody's ever accused him of, flights of intellectual fancy. He's steady, he's workmanlike, he's careful, he's meticulous. He wants a good, solid record. That's what I'm reading. He's not satisfied with the record he has. It remains to be seen what the state's going to do. Let's speculate on that for a moment. Let me throw out a radical idea. If I were the state, if I were Governor Shumlin, I would think long and hard about convening an emergency session of the Vermont legislature in August. And I'd put the question to him, up or down, Vermont Yankee, operate or not. Take a vote, explain the vote, lay out the reasons. None of the chatter, the confusion, the chaos of the 2006 legislative debates, which were a mess to try to untangle. Just a real, clear, crisp statement of state policy. Why do we not want this power plant part of our energy future? That might be the kind of record and final decision he's looking for. Don's right, and Cheryl's right. Those footnotes are a clear signal from Judge Murtha that he's troubled by the state's argument that the PSB doesn't have to, Public Service Board doesn't have to do anything, that the legislature doesn't have to do anything further, that all of a sudden on March 21st the lights shut off and the plant is shut with nothing else happening. He raised that question repeatedly in the hearing, and he never got an answer he liked to that, and he's raised it again in the footnotes in his decision yesterday. So I don't think he's satisfied on this point. I think he wants to see a considered legislative judgment that this plant should no longer operate, and here are the reasons. He may not get that, because I would guess that the governor is not going to take the risk of convening the legislature and taking a vote. If they don't, and if the state goes to trial, they better come better armed with evidence on non-radiological health and safety. They better talk about water quality. They better talk about the fog. They better talk about aesthetics. They better talk about land use. They better talk about what the energy future of Vermont is and why Vermont Yankee doesn't fit in and why there are more reliable and better options for electricity service to the customers of Vermont. They better make that case and make it strong and make it clear and stand up under cross-examination, because Entergy's coming at them with everything they have at this trial. So the state better gird itself, and I think it is. Bill Sorrell today said this was just round one of a long bout. He knows that this isn't anywhere near the end of this fight with Entergy. So I think they are going to prepare, and they better prepare. What's Entergy going to do? It was so obvious that they were bluffing in the courtroom, it was almost embarrassing. If you can feel embarrassed for Entergy, I was almost embarrassed for Entergy, and certainly for Kathleen Sullivan, one of the premier scholars, advocates. She's won more Supreme Court cases than I've watched. standing up there in the courtroom making these asinine arguments about the world is going to end if you don't give us this injunction. So I was embarrassed for her, and I was embarrassed for Entergy to have to make those arguments. But I think strategically it was probably a way of saying to Judge Murtha, we need a decision from you sooner rather than later. I don't think they actually expected to get this injunction. Now, here's the question, though, if you're Entergy. By what I understand, they're looking at a $100 million investment this fall with the fuel rods, the outage, the upgrades, and all. When you add it all up, it's round numbers, it's about $100 million. That's not a lot of money to Entergy. It might be a lot of money to us, but it's not really a lot of money to Entergy probably. But, how confident are you that you're going to win? Confident enough to lay $100 million on the line? Yeah, you'll make some of it back if you can keep operating until March. Enough back to, to make that bet? Is this plant really that viable? Is it really that profitable? We all hear these rumors, right? That, Entergy's looking for an exit, and this is their last show, and they've got to do something for the stockholders. And if they lose, it'll be because the crazy Vermonters shut them down, and the courts wouldn't let them operate, and it wasn't their fault, and they did everything they could, right? This is the report to the board and the report to the shareholders. We fought the good fight. We did everything we could. We couldn't keep it going. We'll move on. Maybe that's what they're doing. I don't know. I have no idea. Maybe that's what they're doing. Maybe not. I think Don's probably right. I think they're going to order the rods and fight this case. The rest of the nuclear industry wants them to fight it. They don't want to see a state shut an operating nuclear power plant down. That's not the kind of precedent they're interested in seeing happen. So there are reasons for them to continue the fight. They probably will, but I don't know that it's a gimme. I don't know that it's a slam dunk decision for them to carry on with this. What else might they do? Let's speculate on that for a minute. Well, they got to think of something, because they threw everything and the kitchen sink at the judge in the preliminary hearings. That litany of safety, 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 and that multimedia PowerPoint, film clip, audio clip, presentation of it's all about safety, Your Honor. These well-intentioned Vermont legislators were creating a pretext because they were really worried about safety, and of course we can understand that, but they have no business being worried about safety and no business legislating on those concerns, and that's really what was going on here. So they've tried that, okay? Now what? Well, in the rules of civil procedure in federal court, all parties are entitled to discovery. There hasn't been any discovery in this case yet. I would not be surprised to see Entergy play that card. I would not be surprised to see Entergy subpoena the governor. I would not be surprised to see them subpoena John Campbell, Peter Welch, the people that were intimately involved in the legislative process that went on in 2006, and put them under oath and say, now you said this on the record then, and this is about radiation safety, isn't it? And that's what was on your mind, isn't it? And that's what motivated you to vote, wasn't it? And that was the deal that you struck, wasn't it? It wasn't? Were those words wrong? Are you telling the truth today, or were you telling the truth then? You've seen this on TV, haven't you? It's real, folks. It happens. I've been up against Entergy. I know how they play the game. It's not beanbags, folks. So if they decide to go bare knuckle, if they decide to go hardball, trust me, they can do it. And they can make life very difficult for people. Whether the judge will let them go that far, I don't know. I mean, there are bounds to this. They're supposed to, act reasonably. It's zealous advocacy, but it's not, backroom brawl. So there'll be a big struggle if Entergy tries to win the case through discovery. But I'm looking at their cards. Don sees their cards much stronger than I do. I'm looking at their cards, and I don't see a winner in the deck for them yet. I don't see a winner in the deck. I don't see that the state has crossed the goal line either. I think this is a pretty up-in-the-air, toss-up competition at this point in the trial. I think what happens at the trial and who succeeds in their strategy in preparing for trial and putting on evidence is the one that's going to prevail. One last thought on the famous Memorandum of Understanding. I do see that issue a little differently from Don, and here's why. I don't disagree that the main event is preemption. But on the other hand, we have a doctrine in law. There's a pretty strong doctrine which says courts should not reach constitutional issues where they don't have to. Very simple, very straightforward, very strong doctrine of law. You do not decide constitutional questions when you don't have to. And you certainly don't decide a question fraught with the balance of power between the federal and state governments, like this one, when you don't have to, right? So the state has offered the judge a way out from that. They've said, don't reach the constitutional issues, Your Honor. Entergy bargained for the right to buy this plant, to operate this plant, to make quite a lot of money out of operating this plant. Entergy signed these agreements, swore to these agreements, supported these agreements over and over again in testimony before the Public Service Board, in testimony before the legislature. Entergy supported at least the initial legislation introduced in 2006, asked for it. It was the dry cask storage authorization they wanted. And it's only now that they found out that they're not going to get their certificate of public good for the next round, that they have disavowed all of those agreements, disowned all of the statements and commitments and promises they've made, and now want to claim that all of those things should not be enforced against them, that they should be relieved of the burden, that those agreements are abrogated by the actions of the legislature. The state has come back and said, what abrogation? You asked for these laws, you testified in support of these laws. If you thought these laws were unconstitutional in 2006, why didn't you sue then? Entergy's response is, oh, well, if we had tried to sue, we would have been thrown out because the case isn't, quote, ripe. Wrong. In the PGE case, that very same argument was made, and the United States Supreme Court said if a state adopts a law that blocks the utility from building a nuclear power plant, that's enough to make the case ripe for a challenge, a constitutional challenge. Entergy had every legal right to challenge these statutes the day they were enacted, the day they went into effect, and they didn't. In fact, they invoked those statutes when they went to federal claims court to recover compensation for the fact that we don't have a federal repository for the nuclear waste that's piling up on the banks of the Connecticut River. So I wouldn't be so quick to dismiss the Memorandum of Understanding as an alternative basis for Judge Murtha to rule in the end. He could very well say, you contracted away your right to sue. You can't control federal law. You can't waive federal law. That's their argument. No, you can't do that. But you can contract away your right to sue, and you did. And I'm going to hold you to that. It's possible, I'm saying. It's possible that Judge Murtha could come down on that. I think that's probably enough jabber from us at this point. Let's turn it over to you for some questions. Go ahead.
Well, actually, hold on.
You're going to moderate?
Well, yeah. I think what we're going to do is if you two want to pull, or just you can either stand, maybe both stand. So what we're going to do is for about a half hour, and I actually might let it go a little bit longer depending on the questions and if people are really getting into this. So what I'd like you to do is just ask a question, and we're asking people to ask a short question and keep it to one question. And then speak loudly and clearly if you can, so we'll all be able to hear. And then I'll ask the two of you to maybe briefly recap the question for those watching at home. So again, keep it to one question and keep it to a question. So what I'll do is I'll try to keep a queue. I'm actually going to try to take, if people are online and asking questions online, I might throw a couple of those in as well, just to dabble in that realm. So I'm going to start with Nancy. I'm just going to kind of go that gentleman right there. So Nancy, why don't you go first?
Okay. Why is the law saying the utility needs a certificate of public good to operate, not considered a perfectly righteous law that the state can follow and entities follow?
I guess that's my field. If you or I, oh, I'm sorry, thank you. Nancy's question was, why is the requirement in Title 30 of the Vermont statutes that generating plants need a certificate of public good in order to operate not a perfectly good law? And I guess the sort of implicit part of that question is, what are we really arguing about here? Doesn't every generating plant need a certificate of public good, right? Yeah.
I think so.
Okay, so here's the answer. If you or I decided that we wanted to open up a conventional non-nuclear generating plant, we would have to get a certificate of public good under Section 248. And that would authorize us to construct the plant. And as long as we continue to own it And as long as we continue to operate it responsibly, we'd never have to go back before the Public Service Board and renew our certificate of public good. That CPG authorizes you to just build the plant. And so what the state of Vermont has done with Vermont Yankee is, and this is unprecedented, is tell Vermont Yankee, you didn't just need a certificate of public good to build the plant and then to transfer the plant to a new owner, but you needed a certificate of public good under state law in order to continue to operate the plant after your federal license expires. So it's that extra step of requiring a renewal that is what we're really arguing here. And I guess, well, since I have the floor, I just wanted, my 5 minutes of rebuttal will be condensed to the following one point. Those of you who read,
This slide just this
I think this just gives you some insight into the way Judge Murtha is approaching this case. If you look at the very last sentence of footnote 2, he's talking again about, like, he's trying to make sense of the statutory scheme that the legislature has adopted. And his last sentence is, it is also unclear to the court, meaning I don't get, how a legislative scheme that does not require final determination of a renewal petition for a nuclear plant, meaning doesn't require the decision to actually be made, is compatible with the safe decommissioning of a plant. In other words, he's saying, hey, you people, even if you are all concerned about safety up there in Montpelier, you know, shouldn't you be taking a final vote so that you can determine whether the decommissioning plan is appropriate, given your interest in safety? So I think Judge Murtha is saying, you know, I am having trouble making sense or interpreting what Vermont, the legislature, did in a way that makes it seem rational. And so that is another reason I think Judge Murtha might be skeptical about the state's position here and more favorably inclined toward Entergy. Now, I have to agree with Pat, you know, we're really just Cliffy and Normie here writing on the back of a cocktail napkin, right? I mean, and you folks are just as qualified as we are to opine about this. I don't know what the court's going to decide. Pat doesn't know what the court's going to decide. I think as I listen to him, other than his spurious argument about the MOU, we're pretty much agreeing with each other.
So you had the next question?
Actually, Patrick dug out probably the biggest golden nugget of the case, and it is the MOU. You cannot imagine a corporation, $14 billion, is going to sign any kind of a legal agreement without very expensive legal counsel. So they cannot say that, I mean, this was not written on a napkin in some watering hole. There was lots of lawyers around, and most of them represented Entergy. When they signed this, they did this in order to operate in Vermont. Now, it's not convenient for them or us to have them in Vermont any longer. So I think that a lot of emphasis should be played in the fact that these people are not unknowingly, uncounseled witnesses and signatories to this agreement, and that we should take that MOU and ride that for as far as we can go, because that is probably the biggest thing we got, is that MOU.
So do you two want to comment then on?
No, that's a good statement.
Yeah.
Leave it there. Lots of hands up, so let's keep moving.
So you in the back, and then Rich.
Hi, I'm Mike Mulligan. I'd like you to consider two scenarios. One where they would find some sort of scandal with Governor Shumlin, you know, they're digging around and all that sort of stuff, and kind of, you know, everybody getting testimony and stuff like that, or something else. You know, these guys are big guys. This is not necessarily about nuclear power. This is about utilities. There's a fear that, you know, power is being taken away from them. So a lot of this is going to be, a lot of these guys are all going to gang up together and consider.
So Mike, if you just want to ask the question, so we have time for everyone to ask.
The other one is, if Vermont Yankee gets into a scandal, say safety system is down and the employees lie about it, and it ends up into a local, regional, or national scandal, how do you think this will play out in court?
Guess I'd have to know what the scandal is. I mean, this is a case about whether federal law preempts state law. So scandals, as we have come to know them, unfortunately, in politics is really not of any relevance to this case. I mean, I think what I was getting at with the discovery was Entergy trying to solidify its claim that the real reason Vermont was acting was safety concerns, not in economic concerns, not land use concerns, not reliability concerns, not anything other than safety. And if they could convince Judge Murtha of that, they win. They're going to win that argument. So the stakes of that are pretty high. That's the kind of, you know, discovery I was talking about. Scandals, I don't know. I don't have any particular view about how other kinds of scandals that might come out in the process would affect the decision of whether federal law preempts state law. I don't think they would.
Yeah, I agree with that. I mean, you folks are neighbors of Governor Shumlin, and I'm not, so maybe you know something I don't. But I can't imagine how, I mean, the discovery, the aggressive discovery that Pat was talking about really involves finding incriminating statements that might have been made in connection with the legislative process, either on the record or off the record, not, you know, some scandalous thing that the governor might be doing. I will say I've worked for 3 different courts, and I spent 3 years working at a federal court a couple of states away. And judges are sensitive to how a case smells. And so if the judges who are going to consider this case get it into their heads that one side or the other is in some sense a bad actor and comes to the court with you know, fundamentally not deserving the court's help with getting what they want, I think those parties tend to find ways to lose when the judge finally issues a final order.
So Rich and Tom?
Yeah, hi, Rich. I'm just curious if you guys, either of you guys or both of you guys, could briefly state what this case looks like going forward, just as far as appeals. It goes to the second court, what information they consider there, what could be very significant there, and then to the Supreme Court, and again, and also timeframes for each court to consider it.
So Judge Murtha has said he'll have a trial in September, and he's promised a prompt decision. I think that probably means a decision by October. The appeal would be to the United States Court of Appeals for the Second Circuit, based in Foley Square, New York City. New York City. And there is a process by which the appeal could be expedited on an expedited briefing schedule, argument schedule. Second Circuit is not known for speed, but it could potentially expedite a case like this. I mean, Entergy, if they lose, Entergy's facing a shutdown March 21st. They may try to get an injunction pending appeal. There's lots of things that could happen. But there could be, and if the state loses, the same thing. They're going to go immediately to the Second Circuit and say, we need a decision from you before March 21st, etc. It's possible, but not likely, that the Second Circuit would issue a ruling before March 21st. Possible, not likely. More likely, whoever wins or loses, if the state wins, the plant's going to have to shut down March 21st pending the appeal, unless they get an injunction pending appeal, okay? So lots of different possibilities. If Entergy prevails, then the state has the burden of going to the Second Circuit and getting a stay of the lower court's decision to prevent the plant from continuing to operate. So best case, I would say it's unlikely that you're going to get a Second Circuit decision anytime more before 6 months from the date that the Judge Murtha makes his decision. From there, just quickly, whoever loses that round in the Second Circuit, you asked what happens in the Second Circuit. Okay, in the Second Circuit, it's limited to the record that was developed in the trial court. No new evidence, no new considerations, briefing and argument on that record. From there,
no new arguments?
No new evidence. Arguments. Plenty of arguments. Plenty of oral argument. Well, the oral argument is limited, actually, usually to 30 minutes aside. About what we have here, supposedly. So you don't get unlimited anything. You get page limits on the briefs. It's a more structured, compact proceeding in the Second Circuit. Getting it scheduled for argument and getting a decision out of the Second Circuit is the difficult part. The Supreme Court only hears cases it wants to hear. This is a big case. It's an important case. It's a constitutional law case. There's lots of markers on this one that says they might take it. Vermont, as our colleague Cheryl Hanna has pointed out, Vermont's track record in the Supreme Court is not good, okay? And Bill Sorrell's track record in the Supreme Court is not good. So you know, a case coming out of Vermont where Vermont is shutting down a nuclear power plant, that's probably the kind of case that's going to be appealing to the conservative justices on the Supreme Court. Yep.
So Tom.
Right. I was also taken by the lack of the MOU in the order. But more than that, I don't see a whole lot about Act 74. The order deals a lot with Act 160. It would be quite possible for the judge to strike 160 and be left with 74, or even strike 74 and then send it off to the PSB. So is that possible?
What do you think?
So the question is really, could the judge declare certain of the enactments that the legislature has adopted unconstitutional without finally resolving the question and basically saying, hey, Public Service Board, why don't you decide the case? Because clearly, in the Memorandum of Understanding, Entergy has agreed to the jurisdiction of the Public Service Board, right? So I think your question is, well, what if the judge just said, all right, Public Service Board, go do the thing Entergy said you could do, right?
Or accept 74, as you say. I'm saying that preemption might not go all the way back beyond 160.
Well, I guess what I'm having a hard time thinking through, because I'm not that smart, is what would happen if the judge were to say Act 160 is unconstitutional, but Act 74, which was the original Vermont bill in 2005, that was the dry cask storage bill, where, you know, that was the first time that the state asserted a right to veto legislatively the relicensure. I don't know. It's hard. I can't quite wrap my brain around Judge Murtha saying 160 is unconstitutional, but 74 is constitutional. I could wrap my brains around the judge saying, all right, what I want to have happen here is I want the Public Service Board to make the decision that Entergy said that it could make. It doesn't seem to be teeing up that way, though, just procedurally. Like if they were going to, I mean, for one thing, Entergy hasn't made that argument. And judges tend not to, they do sometimes, but they tend not to act unilaterally and do something that a party isn't asking it to do. And so I'm guessing that won't happen here.
So I think court and then the gentleman in the back.
Is there an appeal of this injunction finding available to Entergy?
Pat, you're the litigator.
Yeah, they could take an appeal to the Second Circuit from his denial of the preliminary injunction. They face an incredibly uphill battle to do that. He based his decision on facts, not law. He based it on his reading of the witnesses. The Court of Appeals always defers to the trial court on the ability to observe the credibility and demeanor of witnesses. They almost never disturb factual findings of the lower court. Judge Murtha applied the correct law. He applied what we call the Winter decision from the U.S. Supreme Court. This is the latest pronouncement of the Supreme Court on the standards for preliminary injunctions, and this Supreme Court has raised those standards very significantly. So I see no holes in Judge Murtha's decision on the preliminary injunction at all. I think Entergy would be wasting their time and money on an appeal. They've got a clear focus now, and if Don's right, they've got an invitation from this judge to make their case at the trial, and that's my guess is that's where they're going to focus.
Back there.
If you listen to what they're saying, there seems to be a few nails that they're hanging their hats on. One is reliability, and they seem to be trying to frame that as continuous operation. But there's another one that is that seems to be vague in my mind, in that they seem to be pushing that they are now wholesale versus retail. Could you comment on that?
I guess that's my field, but I want to make sure I understand your question. Is your question, what significance of the fact that Entergy is stressing that it is a retail provider or a wholesale provider of electricity?
What I'm saying is, does the fact that they're going to argue that they are now wholesale versus selling directly, primarily to the state of Vermont, providing most of our electric, does that have any impact on how the courts may rule?
Okay, so the question was, does the fact that Entergy is arguing or pointing out, I would say, that it is a wholesale seller of electricity have any impact on the outcome of this case? Would that be a fair summary? And I think the answer is that the correct argument that Vermont Yankee is a wholesale provider of energy undermines the state's case that it is economically regulating Vermont Yankee by possibly deciding to shut it down. Now, Vermont Yankee has always been a wholesale provider of electricity. When it was built by a consortium of utilities from around New England that formed a freestanding company called the Vermont Yankee Nuclear Power Company, I believe, and they were always taking energy and selling it to their utility owners, and sale for resale is what wholesale means. And wholesale energy has always been, or at least since 1935, has been regulated by the Federal Energy Regulatory Commission, or its predecessor. So there is no state regulation of wholesale energy produced by Vermont Yankee. What has changed, by virtue of the fact that Vermont Yankee is now owned by Entergy and not even indirectly by Vermont Utilities, is that we as Vermont electricity customers, apart from our concerns about the physical realities of the plant, we no longer have any economic interest in that plant as a provider of either cheap or really expensive energy, because all of that business risk is undertaken by Entergy, and Entergy is free to sell its wholesale power to anybody who wants to buy it, be they in Vermont or not. Just like Green Mountain Power is free to enter into a contract to buy nuclear power from our friends in the state next door. Did I answer your question okay?
Not really.
Okay.
Well, let me just ask for a clarification. So is an appeal to FERC a possibility?
No, because FERC's concern under the Federal Power Act is the rates that Vermont Yankee is charging. And there are no energy transactions, meaning agreements by Vermont Yankee to sell at wholesale, that are at issue in this case at all. So there's no opportunity here to get before the FERC. No reason to, really.
Nick, go ahead, and then Randy. Go ahead.
We've heard mention of the stellar legal Entergy people. What about the state? And what about the legal community? I mean, you made a whole list of possible alternative arguments, not safety. I'm sure the state is thinking about that. So are they responsive to outside support, ideas? What is the mood and the communication in the legal community?
So the question is the State Attorney General's office that's handling this case for the state open to suggestions, looking for support, and up to the task, perhaps, of going up against the talent of Entergy? Is that the question?
That, and what are their skills and their expertise?
Yeah. So, and what are their skills? So Scott Klein heads the team. Help me with Bridget Assay, I think, isn't it? Bridget Assay, I believe is how she pronounces that, who argued, unfortunately she lost, before the U.S. Supreme Court this term. Justin Kolber, who's a VLS Vermont Law School product, we're very proud of, worked with me in the clinic, is on the team. And there's a fourth member, a young man whose name escapes me, forgive me, it's an adult moment, I mean, a senior moment. I would say this, that, you know, do they match Entergy's sort of star quality firepower? No. No. To be honest, no. Are they competent, capable, hardworking, smart lawyers? Yes. Can they win? Yes. Are they open to suggestions? Depends on the suggestion. I hope they're not overconfident. I actually hope, I would like to have Don give him his speech, because the worst thing that can happen to them at this point is to take too much solace in this victory and think, you know, we're okay, we're going to win. I would not be thinking that way. I would be thinking we should have had a ruling from this judge on the merits. We should have had this judge say it is unlikely that Entergy will prevail on the merits. We should have seen a ruling like that in this decision if the state had done everything it needed to do. That was a red light to me, flashing, because Judge Murtha said going into the hearing, the main thing I want to focus on is the merits. What I really want to tackle is the question of preemption. He flipped after the hearing and said, I'm not going to talk about the merits at all. I'm only going to rule on the irreparable harm. In my mind, the state lawyers better take that to heart. They better redouble their efforts. They can win it, but they're going to have to work at it.
You know, I just want to say in response to that, as I said before, I've worked for a bunch of courts, 2 state Supreme Courts, 1 federal court. And it's the rare case, and I don't think this is such a case, that the outcome really turns on the quality of the lawyering if both sides have perfectly competent counsel. This is a hard case to argue, and I respect and admire the skill and the passion and the, as far as I know, the ethics that all of the lawyers I've watched in this case have brought to their work. And I think whoever wins will win because they had the better argument, not the better lawyer.
So, Randy? I think it was you, Don, who made some reference, perhaps based on your federal and state court experience, to the fact that, and correct me if I've got this wrong, that there are cases in which the court, although maybe not ever admitting it, clearly takes into account whether one side or the other is coming with, what's the expression you lawyers, unclean hands. Or
Yeah,
some,
yeah, that's a doctrine.
That they don't deserve. Is that tantamount to saying, in a more broadly, that, again, though they would never admit this, I presume, that judges are also sensitive to public sentiment in general and the climate of public opinion in certain instances in your experience?
Go ahead, if you want.
Sure. I'm not a cynic about the law. I don't think I'd be a law professor or a lawyer if I thought that the process were fundamentally corrupt and intellectually dishonest. All the judges I know personally go to work genuinely striving every day to do the right thing. And I have no reason to suppose, although I don't know any of the federal judges that are going to be involved in deciding this case, I have no reason to suppose that any of them are cynical or venal, and there's nobody sitting in their chambers going, blah, ha, 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 you know, I love nuclear power and we're really going to stick it to the state of Vermont here. I don't care what the law says. I mean, but judges are human beings, you know, they're vulnerable to, we all tend to think of ourselves as so fundamentally well-intentioned that it's hard to examine our motives and our actions skeptically. And I think, you know, judges are not impervious to things like public opinion, their own policy preferences, and their general orientation in life. And I look at the Supreme Court sometimes, and I look at, because I'm a liberal person or a Democrat registered, I tend to be critical of the so-called conservative justices, and I notice that there's a really strong correlation between the decisions they make and the policy preferences they've articulated. And I think, gosh, I'd feel better about Justice Scalia if I could think of more examples where he made a decision that's clearly at variance with what I know his personal political opinions to be. That said, I would urge people to really expect and assume that whatever decision gets made here is a genuine effort by the ultimate decision maker to do what they really think is right. I don't think the process is corrupt.
I didn't mean to imply that it's corrupt, only that, as you said, they are human beings who bring into their own processes, however objective they like to think of them, other considerations, including public opinion.
Sure. And they read the newspaper, too, by the way. Don't kid yourself.
Pat, do you want to weigh in?
No, that's okay. I know unless there's no other questions. Then there is some questions.
Yeah, I wanted to point out that Lauren Soclair here, who manages the evacuationplans.org website, has on the website there's the 18 pages of the decision is available on that website.
It's on our website too.
evacuationplans.org.
Yeah, it's on our website.
So for everyone at home and for everyone, the Vermont Law School actually has all of this, majority of it, on their website, including blogs by the two of these gentlemen here, as well as Cheryl, about this issue. So I'd encourage people to go to those websites to read a little bit further. And I'd have to say, too, several people have been commenting on that, and I think a really good dialogue has been generated from those comments. So, but evacuations.org.
Commentaries are terrific. By the way,
Yeah.
I've already read theirs and Cheryl's too.
So, are there any other questions at this point? Court? Yeah, go ahead.
It's my second one, if I can.
I just saw no other hands, so
Okay.
you are the one to go.
What is the efficacy at this point of friend of the court briefs coming from other states? Do they have a role, and are there any right now that are really active and forward?
4 briefs were filed. We call them amicus briefs, friends of the court. Judge Murtha makes one sentence reference to having read them. The one that probably would have the most effect, if it has any, would be the one filed by the Commonwealth of Massachusetts. Because Massachusetts has a statute that's even more aggressive than Vermont's with respect to the state's assertion of control over the future of nuclear power plants, including the Plymouth plant that's owned by Entergy. Massachusetts took no position on how the case should be decided in filing its friend of the court brief. It merely brought to the court's attention the fact that there are other states in similar situations facing similar decisions, and of course the Commonwealth was quite concerned that the court take into account that the effect of its decision would ripple through other states in the region, a fact that I'm sure Judge Murtha was already aware of. But having the Commonwealth of Massachusetts state it officially, publicly on the record, I think was beneficial to the state's case. I don't think it makes the difference in the end to the outcome, but it certainly helps, doesn't hurt. At this point, there won't be any other, there may be attempts to file amicus briefs on the merits, and the judge has said before, I will consider each one case by case, and if I think it's adding something of value, I'll let it in.
Please explain what you said, Massachusetts has something even stronger?
Yes, they do. I can't remember the details of their statute, but they go into much more detail on storage, radioactive waste disposal, at least what was cited in them. I believe, yes, we do. The Commonwealth's amicus brief is on our website. It's short. It's 13 pages. You can read it yourself.
And that's vermontlaw.edu.
Right. So you can read it, and you can see exactly what the state law is they're referring to.
I think we have time for one more question, and then we'll go on.
Follow-up. Can friends of the court come in at the district court level or beyond?
Yes, both. It answers yes to both. Actually, friend of the court briefs are even more effective the higher up you go. So in the Second Circuit, there would be an opportunity for that. In the United States Supreme Court, some of the justices rely fairly heavily on amicus briefs to educate them about the broader technical, scientific, and other economic issues that are involved in constitutional cases. Justice Breyer has written a lot about this, for example, and Justice Kennedy on the other sort of wing of the court has as well. So, yeah, when you get up to those upper echelons of the judiciary, you know, the more that a case draws the interest of a broad cross-section of American society, the more the courts will pay attention. So I guess that's it.
Any further questions at all?
Can I ask a quick one? Is there any precedent in the courts for a state's ability to regulate environmental concerns versus the preemption issue on radioactivity?
Yes, there are statutes like the Clean Water Act, for example, that explicitly authorizes the state to issue permits for the discharge from Vermont Yankee and to certify the NRC license as being in compliance with Vermont's water quality standards. Some of you know, NEC certainly does, that there's a case pending in the D.C. Circuit Court of Appeals challenging the NRC's reissuance of the license on the grounds that Entergy did not secure a proper water quality certification from the state of Vermont. Were that case to succeed, it's not going to come down in time to affect this decision. But if that case were to succeed, it would knock out the NRC license to operate the plant. That could stop the operation of the plant. So that's a whole other legal action that's proceeding in the background at this point. but it could pop up at some point and be dominant.
That's my question. Is there precedent for that?
Yes.
Do you know what those are?
Pardon?
Can you cite those?
Yes, it'd be PUD number 1 of Jefferson County versus Washington Department of Ecology. It's not a nuclear case, but it doesn't matter. It's the Clean Water Act. It's a 401 certification. It's the same for a nuclear plant as it is for a hydroelectric plant, as it is for a coal-fired power plant. The Clean Water Act applies to all of them. They all require compliance with water quality standards. The states have the absolute authority to veto federal permits and licenses that don't comply. Now that could, well, I don't need to go on, but that may not be an absolute showstopper of a case. It may mean that Entergy has to go and get the certificate. That will be an interesting point for the state. Will they issue the certificate as they have done religiously in the past, or this time will they say no? That'll be an interesting moment in time.
I think just because of time we have to move on. I think it's actually a great point to segue to. So let's give Pat and Don a round of applause.
Thank you. Thank you.
We really appreciate them making the trip down. And I think Pat's comments segue really well into the next section. We're going to have Clay Turnbull from the New England Coalition talk a little bit about the New England Coalition's work in a couple of suits that they have going on at present with the Nuclear Regulatory Commission and the Public Service Board. So I'll turn it over to Clay.
Yep. Hi, everyone. It's a friendly crowd. I feel like we should do that stand up and stretch. Having listened to all of that, that was a lot for me to try and grab a hold of. And I'm not as good at reading paper as they are, so I've made myself some notes. First, I'd say I'm Clay Turnbull from New England Coalition, originally New England Coalition on Nuclear Pollution. As much as we've invested in this case, there's a number of other things going on that I think I'm asked to just give you a brief update if you knew about them or if you're not sure about what they are. But first I want to say, why did Entergy wait the 5 years? Why didn't they do this way back when? And our position, one possibility, is they were waiting at this level to say, well, we have NRC approval. We're a safe plant. You know, NRC's given us the thumbs up. And so many people here and in this area have for, the past 5 years been hammering away to prevent NRC approval that Entergy's now using that card. Well, we're a safe plant. So I don't know what the word is. It's a bittersweet victory, maybe. I don't know if that's quite the word, but that it's taken them 5 years to get to this point. I know in that when the NRC had their affirmation session about license renewal, and affirmation session is when the commissioners got together and they had their discussion and took a vote amongst themselves. Less than a day later, we all know what happened in Japan. And while they were having that affirmation session, that day, we had filed to stop that vote from happening because of an issue of underground cables, submerged, underwater cables submerged, safety-related cables and wiring submerged that aren't designed to be there. And the following day, wouldn't you know that a failure of those cables, those very systems, are what failed in Fukushima. So we got to keep on fighting. I mean, as we all know that. We all know that. But let's keep at it. Right now in front of the Vermont Public Service Board, still open, our docket 7440. I got an email, a question, what's a CPG? It's the Certificate of Public Good. They still don't have that. That's what we're now at this federal court case. But even before we get to go back to 7440, currently open is docket 7600, which is the docket that opened as a result of their announcement of underground pipes leaking tritium, the pipes that didn't exist. As recently as the 1st of July, we filed with the Public Service Board saying the information that Entergy's been filing to you twice a month, as required under part of docket 7600, the information they've been filing every 2 weeks appears to be either incomplete, inaccurate, because the NRC told us they've done all of this and showed us the reports that they had done that. But they're telling the state of Vermont a different tune. Sometimes I get lost in what the public actually understands about all this stuff behind the, do people understand the basic premise there that they've been telling the state one thing, but they told the NRC another thing? And it's almost like possibly it's a repeat of the inaccurate information about underground pipes. You never know where this is going to lead to. That one little statement that took place at the NRC meeting last month, one little bitty statement that the NRC guy said that we've got the reports that show that they solved the tritium leak. It's fixed. They fixed it way back when. But they're still telling the state, well, we're looking, we're going to do some more tests, blah, 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 blah. So, so that's still happening. Docket 7600 is still wide open. I don't know where preemption comes in on docket 7600. It's a question I leave to the lawyers. I just keep fighting. Beyond nuclear, New England Coalition and a number of other national groups have petitioned the NRC to shut down General Electric boiling water reactor Mach 1 containments until NRC has incorporated lessons learned in Japan. To us, it's just insulting that they wouldn't do that they wouldn't say, hey, let's see what's happened in Japan. And while there's a lot of disdain in this room for NRC, we have to fight that fight. We just got to keep doing it. It's a bureaucracy that doesn't want to change, but we're going to make them. I think that's all I have. All I have to say. Any questions about any of the? Yeah.
Not a question, but I guess just responding to what you said. And I so enjoy the discussion from the legal point of view, but when we think about it, this event that's happened over here and the lessons learned or the lessons being learned, how could that not be relevant to this case? I understand it's outside of the case, so it's irrelevant. And at the same time, how could it not be relevant?
The beauty of the seat that I'm in is I'm not confined to law. God, I couldn't do it.
It is a liberating experience. You're not the only one not confined to law.
So, yeah, I think that the personal statement I would make is a long time ago I learned from Ray Shaddis that the best we can do is just keep pulling the truth into the light. Just keep shining the light on what's happening there. And whether it's public demonstrations or tangles in the lawsuit or another dry teleconference meeting with NRC, it all plays a crucial role. We heard tonight, democracy's working. And we also heard, well, it costs money to play in this democracy, right? So I personally, I celebrate and I say, God, we got a lot to do. And thanks for being here. Thanks for coming out.
Thank you.
Thank you, Clay. And Clay did write up the New England Coalition's website as well. It's www.necnp.org. So definitely check that website out for their work that they're up to. I think Again, I appreciate you gentlemen segueing so well into the next section. So we'll have Nancy Browse from the Safe and Green Steering Committee talk a little bit about the Safe and Green activities and where the legal and the activism kind of bleed together. So, Nancy.
I just want to apologize. I am not feeling that good, so I'm reading a statement. I didn't really have time to prepare well, so. We in the Safe and Green campaign applaud and are encouraged by yesterday's decision by Judge Murtha to deny Entergy's request for a preliminary injunction. But assuming Entergy itself doesn't decide to pull the plug on Vermont Yankee prior to mid-September, when the so-called merits of their lawsuit go to trial, we know that as concerned citizens who live in the shadow of Vermont Yankee, our efforts to make sure Vermont Yankee closes on schedule on or before March 21st of next year are certainly not over. In fact, depending on the final outcome of these court proceedings, our role may be far from over. We need to remember that without vigorous citizen actions during these past years, actions such as educational forums like this one, legislative lobbying, town meeting resolution campaigns, demonstrations, rallies, and public protests of all kinds, we would not be as close as we are now to shutting down Vermont Yankee and ensuring a bright, nuclear-free energy future for Vermont. In short, our efforts to date have been successful, and we should celebrate that. At all times, Entergy has been far better funded than those of us fighting Vermont Yankee, with all the advantages deep pockets can bring. Yet their slick advertising, lobbyists, strategic community donations, and propaganda could not buy the hearts and minds of Vermonters and our neighbors in Massachusetts and New Hampshire. We who live near the reactor have been told to trust the NRC to protect us and our families, the public health, and the environment. Instead, we see an agency with a revolving door hiring policy and an unwillingness to challenge the industry it's supposed to regulate. The recent series of powerful Associated Press stories highlight and make specific what we've always known, that the NRC is an industry lapdog, more interested in getting along with reactor owners than in the safety of reactor communities. And now in recent months, we've watched with outrage Entergy's attempt to subvert the democratic process by going to federal court in order to throw Vermont laws and the will of the people under the bus. For all these reasons, we know that we citizens must remain vigilant and active throughout this court process, and we must remember that if, in the final analysis, the courts refuse to uphold Vermont laws, its democratic processes, and the will of its people, we may have to exercise our democratic and inalienable right to do so ourselves by means of nonviolent and direct action. So stay tuned and join us.
So thank you again to Pat and Don. That was a great discussion, I think. And I really, again, strongly encourage people to go to Vermont Law School's website to follow the blog. Are you two going to be blogging anymore? Okay. And Cheryl as well? Okay. So definitely go to their website and check out the resources there and continue the dialogue. All of this, including tonight's event, will be, it's being recorded. Thank you to Brattleboro Community Television, Clay, who's kind of playing two roles here tonight. That will be broadcasting very shortly, both on the station as well as online. We will be posting this event, the recorded event, on the Facebook page. Again, that's facebook.com/shutdownvermontyankee. And we'll be continuing to post updates, news, and events. So I did want to lastly just announce a couple of events that we've got going on, especially a couple right here in the next week or so. So Randy, do you want to talk briefly about the clamshell event?
There's going to be a conference this weekend at the World Fellowship Center in Conway, New Hampshire, being called by, what do I say, veterans of the old renowned Clamshell Alliance that really instigated a whole wave of citizen opposition to nuclear reactors in the 1970s. And the focus of the day on Saturday, this coming Saturday, for anyone who would like to attend, is going to be Vermont Yankee. And all voices are welcome to come and talk about what is the role of citizens. We know what the lawyers are up to who are defending Vermont's position from the Attorney General's office. What can citizens be doing during this time? And what should or could citizens do if in fact, as Nancy's statement said, the Vermont courts refuse to uphold Vermont law, Vermont's democratic processes and the will of the people of this state and this region. So that's this Saturday, Conway, New Hampshire, the World Fellowship Center.
That's the other one too.
Great, thanks. And then, yeah, so there's actually a couple of events going on this weekend in Burlington at the university. Is from Fukushima to Vermont, the Vermont's Nuclear-Free Future. That'll be happening at the campus this, double check the time, I believe on Friday, is that right? Or is that on Saturday? On Saturday, starting at 10 a.m. And again, all of these events are listed on the Shutdown Vermont Yankee Facebook page. Bob, did you want to talk about the walk?
The weekend after this coming one, the 30th and 31st, Peace Pagoda people from New York they're doing a walk from Plymouth to Seabrook to Vermont Yankee to finally to Albany. And they'll be coming through this area that weekend, the 30th and 31st. And there'll be one or two potlucks at Amazing Planet Farm in Dufane, and we'll also have something posted about that.
Yep.
And they're also encouraging people, the walkers, to join them on the trek from, they'll be doing Keene to Vermont Yankee, to Brattleboro, and then heading west on Route 9 to Marlboro and Bennington.
Cool, thanks. And then finally, and kind of going off of a little bit what Nancy was talking about, if this case does not go the way that many of us are hoping that it will go, we still will continue our struggle. There's no way we're stopping at this point. So to energize for that potential, we are organizing a music festival, the Positively Charged Music Festival, on Saturday, September 17th at the Amazing Planet Farm in Newfane. The whole idea is to get people charged up and excited and recruited for any potential civil disobedience or actions that we'll be planning if our democratic process is usurped. So again, look for all of these events on our Facebook page, as well as the Safe and Green Campaign.org website. Again, thank you all for coming tonight. Enjoy the rest of the evening, and thank you too for being here.